Mr. Ross?
Mr. Chief Justice, and may it please the Court, there is nothing race-neutral about Alabama's map. The District Court's unanimous and thorough, intensely local analysis did not err in finding that the Black Belt is a historic and extremely poor community of substantial significance. Yet Alabama's map cracks that community and allows white black voting to deny black voters the opportunity to elect representation responsive to their needs. Rather than argue clear error, Alabama asks us to ignore statutory stare decisis and to rewrite Section 2's text. But the Voting Rights Act is a remedial statute that Congress has twice reenacted since Gingles, and its application here raises no constitutional concerns. That is because plaintiffs' maps show, consistent with Bartlett, that it is possible to draw maps that look very similar to Alabama's own Board of Education map, and that increase opportunities for minority voters while satisfying traditional and state redistricting criteria at least as well as Alabama's map. Nothing in the text of Section 2 allows Alabama to avoid liability by offering up these post hoc rationalizations of simulations and core retention for maps that result in discrimination. In fact, Alabama called simulations fundamentally flawed for not reproducing its own map and for not incorporating all traditional redistricting criteria. At Gingles 1, this court requires us to use sample plans that Alabama is not ultimately obligated to adopt. But those plans need not be the ultimate remedy, and that's because, as this court said in Brnovich, Section 2 looks at the totality of the circumstances, not as Alabama would have it, the totality of just one. Section 2 is not an intent test or about putting on racial blinders. It is about equal opportunity that Alabama's map denies black voters. Thank you.
Counsel, do you agree with the Solicitor General's statement in her brief? I don't know exactly what the page is, that the argument that your friend on the other side makes about the race-neutral simulations, that argument can be taken into account under the totality of the circumstances?
Your Honor, I think simulations are about intent and they're not about results. But if it were to be taken into account as a part of the totality of the circumstances, I think it could be a factor that goes to an issue of remedy. And here we know that Dr. Deuel conducted simulations using race as one factor among many others and said that she could create literally thousands of two districts with majority-minority districts. And even EMI, where he used race-blind simulations, came out with plans that looked very similar to the Singleton plan, which allowed for two crossover districts where minority voters would have a fair chance to elect their candidates of choice in at least two districts.
Can I ask you about the first Gingles precondition? What the court said exactly in Gingles was that there must be a sufficiently large, that the minority group must be, quote, sufficiently large and compact to constitute a majority in a reasonably configured district. It didn't say in a reasonably compact district. It said reasonably configured. So would you agree that whether a district is reasonably configured takes into account more than simply whether it is compact, but also whether it is the kind of district that an unbiased mapmaker would draw?
Your Honor, again, Section 2, as you know, is about intent and is about results and doesn't speak to intent. And so, with respect to the biases of a mapmaker, I'm not sure if that's relevant, but I will say, as this court has acknowledged, that Gingles 1 does take into consideration compliance with traditional redistricting criteria, and those redistricting criteria that that this court has listed are compactness, contiguity, respect for communities of interest, and political subdivisions. And the district court found on all of those that plaintiffs' plans meet or beat Alabama.
So even if a computer simulation that takes into account all of the traditional districting standards would almost never, in a million simulations, it would never produce a second minority district, this first Gingles factor is satisfied?
Your Honor, that's not the case here. Again, plaintiffs' experts.
Yeah, it's a hypothetical.
I understand,
but if that were the case, would the first Gingles criteria requirement be satisfied?
Your Honor, I'm not sure, because this court said in Bartlett that plaintiffs were required to draw an additional majority-minority district, and so perhaps it would go to the fact that, that maybe you can't have a remedy that meets Gingles 1, but I would also say that you have the option of drawing a narrowly tailored district where race may predominate, as this court recognized in Bethune-Hill.
So you think that the first factor is satisfied, the first requirement is satisfied if it's possible. You set out to draw this second district. You want to maximize. And if you can do that, you satisfy the first factor.
Not at all, Your Honor. We're not saying that satisfying Gingles 1 requires maximization. And as I said, it's certainly possible that if you can show that it's truly impossible to draw a compact district, then no, you wouldn't get a second, you wouldn't satisfy Gingles 1. And I think what's important here is, a plaintiff's expert said it's possible numerically to draw 3 districts, but she didn't set out to do that. What she set out to do was to draw districts that look very much like Alabama's map. And this is not, again, the map that anyone has to adopt. It's an illustrative map. There are maps out there in the Campaign Legal Center amicus brief, in the Singleton plan that don't require maximization.
Well, if she could draw 3, then why isn't that required?
Because this court
that
has
would exceed the proportion of black voters in Alabama?
Not at all, Your Honor. My point was merely that numerically it's possible to draw more, but plaintiffs aren't asking for that. Plaintiffs aren't even asking for a map.
Suppose you did. Would you satisfy the first Gingles factor?
I don't
think
you could.
Here is a map. We come forward. Here is a map. Produces 3 majority-minority districts, and it's compact. It's they're reasonably compact. So you satisfied the first factor.
No, Your Honor, because you need to look at. Perhaps you could satisfy the first factor, but I don't know. It's unlikely that you would be able to meet the other factors. In the Grandy, this court said.
What if you could?
Your Honor, I don't think that Section 2 of the Voting Rights Act at all requires maximization, and here you couldn't meet Gingles 1, and so we're not in any way suggesting that. And one other, Your Honor, what plaintiffs are really looking for is not any sort of guarantee of a second majority-minority district. As I said, we'd be satisfied with something like the Singleton plan, which Alabama's experts said would give black voters at least a fair chance, not even a guaranteed chance, to elect their candidates of choice in a second district. That's merely what plaintiffs are looking for.
Counsel, if we were to say, as opposing counsel is now claiming, that you have to show the possibility of a second district on a race-neutral map, do we vacate and remand? Do you have enough below to win even under that standard?
Your Honor, I'm not sure what Mr. LaCour means by a race-neutral standard. I think certainly it is. This is up on a preliminary injunction, and so if there were a standard that became a new standard, then we would, like it to be remanded. I think that any standard that requires some sort of race blindness, as Alabama is saying, would not only make it difficult for plaintiffs to satisfy Gingles 1, but would make it difficult for states to draw, the 435 congressional maps that we have.
Now, opposing counsel in his summation was talking about the idea of race neutrality. Section 2 was really aimed at a results test, equal opportunity or participation. Section 2 is not being used that widely, is it? I read Amikai Chen's brief, and he says that there's only been 31 vote dilution cases that resulted in merits decision over the last 2 redistricting cycles. That's out of 435 plans, and that only 8 were successful.
I believe that that's true.
And Gingles itself makes this remedy available only in an extreme circumstance where voters are polarized completely and where there's no crossover between the races, correct?
That's correct, Your Honor, and where you meet the
so
totality.
Alabama itself is unique in that regard, isn't it?
Absolutely, Your Honor. There's racially polarized voting in Democratic and Republican primaries. There's racially polarized voting in general elections. And there's a very recent history of racial discrimination in Alabama that may not exist in other states.
That was part of the totality of circumstances the
Yes, Your
district
Honor.
court found to suggest you're describing Alabama's cracking of the black district for decades, correct?
Yes, Your Honor, and I do want to point out that on the stay appendix at page 177, the district court did find that Alabama cracked the black belt.
Thank you, counsel. Justice Thomas?
Thank you.
Justice Alito? Justice Sotomayor, anything further? Justice Gorsuch? Justice Kavanaugh?
The other side says that the proposed districts are not reasonably compact. And as I was mentioning, I think compactness is the key under our precedents to interpreting Section 2 correctly and the equal protection requirements. And they say the district's too sprawling to be considered reasonably compact or reasonably configured. And I just want to get your response to that, because I think that's the critical point here.
Yeah. Yes, Your Honor. Again, I think the district court's findings, which are subject to clear error, made clear that plaintiffs' plans met or beat Alabama on the compactness requirement. With respect to, Alabama's allegation that our map goes, that our plan goes across the state, so does some of Alabama's plan. And again, Alabama's own Board of Education map, which was drawn at the same time using the same redistricting criteria, which in Alabama's guidelines includes race, created virtually the same district that also spreads across the state. And then, Your Honor, you had a question earlier about, what these traditional redistricting guidelines are. This court in Perry versus Perez recognized that, when you're drawing remedial maps, that you have to take in consideration state and local redistricting criteria, except to the extent those criteria violate Section 2. And here, core retention is nearly always going to violate Section 2, and our plans tried to take that factor into account as much as possible without perpetuating the violation.
Thank you.
Justice Barrett?
Just one question. If we interpret Gingles Step 1 as you propose, is the result of the test to say that a state must maximize so long as it can do so in reasonably compact districts?
Not at all, Your Honor. This court has recognized for 30 years that maximization is not necessary. And just because you can draw an additional district doesn't mean that you would satisfy any of the other racial polarization, a totality of the circumstances, and that's why this court in DeGrande added in proportionality as a part of the totality, so that it prevented maximization from being a goal of Section 2.
Thank you.
Justice Jackson?
And I would take it that is why this whole Jingle scheme has been thought of as self-liquidating in a way. It's because it only triggers in situations in which you have this compactness, presumably due to the racial polarization or stratification of this kind of district, and people are continuing to vote in racially blocked ways. But if that stopped happening, if what we all want, which would be people to spread out and live among one another and vote based on their, own views as opposed to along racial lines, then we wouldn't have a Section 2 violation. Is that correct?
That's exactly correct, Your Honor. And, I think it's really important to take a look at the Stephanopoulos brief, which makes that point, and also the computational redistricting amicus brief, which makes the point of how, using computer simulations are really not the way to get at the issues that Gingles 1 is concerned with.
Thank you, counsel.
Thank you, Your Honor.